Are we live? I am Madhur Rathore, founder director of Lexpeeps, and I welcome you all to Lexpeeps live session on how to file and draft PIL with Advocate Jayant Bhatt. I would take a moment to introduce Lexpeeps to all of you. Lexpeeps Private Limited is an organization that works to assist and help law school in organizing and managing their events. We are seeking to provide young and dynamic law students a platform to experience the legal world in their academic capacities. We organize different events where budding lawyers can experience the legal world with a self-directed educational strategy and the guidance of industry experts. Lexpeeps also provide you with the recent happening in the legal world in the form of news opportunities where you can find what suits you the best, articles to explore your interests, and many more. Lexpeeps is also working on different courses which will be releasing very soon. Now, ladies and gentlemen, I will take another moment of yours to introduce our today's guest, Advocate Mr. Jayant Bhatt. Sir is an independent lawyer based out of New Delhi. He has 12 LLM from New York University and National University of Singapore. He regularly features in news articles and webinars. No words can suffice how well he is in mentoring and imparting knowledge. It's a pleasure for Lexpeeps family that he has taken out time once again for this workshop. Welcome to the event, sir.
Thank you so much.
Thank you, sir. So now we can begin with the workshop, and I would request all the participants to be with some notebook and pen because everything is going to be very important, and it is a very crisp session. So try to note down what are the things, and in case you have any questions, you can put it in the comment section.
Right. Thank you so much, Madhur, for that wonderful introduction. And first of all, I hope everything is well at your end, and even the audience who have joined us. These are very difficult times, not just for the country, but for the world. And I sincerely hope that you are all taking care, wearing masks, sanitizing, and regularly washing your hands. That is very important. And that's the least we can do to fight this virus. The news which is coming from every quarter is very disconcerting. And I think these are the times when we as human beings and as individuals must realize that how important the role of lawyers become in the society. So much so that when we are talking of public interest litigation, having said that, my purpose is never to bore people or make it very verbose. And contrary to what Madhur has said, I always tell people don't take a pen and paper in my class. Just be attentive, because if you have heard what I'm saying, and I don't know if this is live on YouTube or any other platform, then you can always watch it later. With technology, a lot of things have become easy. The real pen and paper that you need to use is your brain and your thoughts. So if you can ink something in your brain with your thoughts and with what I'm saying, if it resonates with you, by all means, I think we would have a good session. I'll not try to make it very lengthy because we all know, and considering some of you are young lawyers, some of you are also young law students who will tomorrow be practicing attorneys, you must have all already heard of what public interest litigation is. To give a very brief overview, the whole idea of public interest litigation was launched in India by great Justice Krishna Iyer and Justice Bhagwati of Supreme Court of India back in the 1980s. And a lot of it is drawn from American jurisprudence, from other European jurisprudence, whereby the concept of coming to court by a public spirited citizen was, as an idea, first mooted in the 80s in our country. And that also gave the idea of judicial activism to the court. And there are numerous judgments by Supreme Court of India saying that yes, a public interest litigation can be initiated by someone who does not even have a locus. So, for example, today, if I see anything which, as a public spirited citizen, I feel deeply about, and I think has a wider impact on society, and needs the attention of the court, for which either there is no law, or if the law is too slow, or if there is some sort of violation of law which is happening, which can be avoided, and the courts need to step in a public domain, then that public spirited person, for something to be done in the public domain, can file a public interest litigation either in any of the high courts in the country or in the Supreme Court of the country. Now, there are two main articles, and by and large, I would tell you a PIL or a public interest litigation, whenever it's filed and entertained by the High Court in the country, it is filed under Article 226 of the Constitution of India. And if you have to do it in the Supreme Court, that is entertained under Article 32 of the Constitution of India. That is basically the writ jurisdiction of both these constitutional courts. We all know there are five kinds of writs. I'm not going to take you there. So, when and how do we file a public interest litigation? What is the type of format that we have to keep in mind? So I must tell you the format. If you go to a lawyer, if you're not a lawyer who is tuned to the channel right now, I would suggest please go and speak to a lawyer nearby, your locality or in your friend circle, in your family circle, who can guide you the right manner in which you can file and argue a public interest litigation. So let's go a few steps back and ask ourselves, why and how do I file a public interest litigation? The why question I answered because of judicial activism in the 1980s, so on and so forth. We have hundreds of judgments. The very famous judgments we keep hearing when we're in law school are a lot of MC Mehta matters, which are environment centric, where too many things about MC Mehta's case are discussed time and again. There are other matters of public importance, such as child labor, bonded labor, sometimes matters of children who are neglected, exploitation of casual laborers, non-payment of wages, matters of harassment or torture to persons belonging to scheduled castes, scheduled tribes, or economically backward classes, either by a faction of society or by police or by some other governmental body. Matters of environmental pollution, especially mining cases you may all have heard of, disturbance of ecological imbalance, the forest wildfire that we keep hearing in Uttaranchal now, food adulteration matters, maintenance of heritage, cultural antiques, forest, wildlife, etc. And petition sometimes from riot victims. We have seen few riots in the past, in the recent past, also in the National Capital Territory and other parts of the country. And matter of other public importance are normally and by and large entertained by the court of law. And when I say court of law, I mean both the High Courts and the Supreme Court of this country. Now, let's draw a parallel to what is going on today. I think today, when you open any news channel, especially a legal news website in the country, you see a lot of PLs are being entertained by different high courts, especially during the pandemic times. These public interest litigation can range from anywhere between people filing petitions for getting a hospital bed in a hospital because of the pandemic. People are filing petitions to get medical equipment like oxygen concentrators, medicines like remdesivir, or any other medicine which is required to fight corona. Again, people are filing petitions to ease certain curbs and to allow certain officials to have a free movement across the borders of the state, or if in a particular state there are, I think just 2 days ago in Delhi High Court, or maybe in Supreme Court, I'm not very clear. I think one of the High Court has given direction, or I think a PL has been lodged, where it says for the migrant laborers, please provide dry ration. I think again the central government, I think union has been made a party. So all these petitions are there to highlight the plight of the society and how people are suffering in this pandemic. So that's a very clear thought that we have. We are all homebound, most of us. We have seen how painfully people have been looking for beds, how people have been running from pillar to post for oxygen cylinders. So many high courts have now taken cognizance of this matter. Some of the high courts have taken suo moto cognizance of the matter under the power prescribed to them, under various high courts laws and the rules, and have made them, into a public interest litigation. And by virtue of those public interest litigation, the central government and the state government have now been asked pertinent questions. And let me take the example of oxygen cylinders. For example, now India is also getting a lot of aid and donation from foreign countries and from the countries where we share very good relationships in terms of machines which are procuring oxygen, cylinders containing oxygens, medicines which are flying in cargo and getting shipped from foreign countries. So now courts have also systematized this whole system of public interest litigation and have made different authorities of the state bodies and the central government agencies a party to pointedly ask them a question. Please tell us, in what quantity are these medicines coming? What is your game plan to distribute these medicines? So why am I telling you this? I'm telling you this because the whole concept of public interest litigation and going and agitating these issues to the court is to formulate a strategy to help the society, is to formulate a structure to help the people of this country, to enable people who are suffering, either especially during Corona times. And let me be very current about this topic so that we can relate more to PIL, so that people can be helped in the times of utmost crisis. Now, another important topic I think that Lexpeeps has kept for today is the drafting of PIL. Two ways of drafting. Number one, a very simple letter, even a handwritten letter, but clearly handwritten, or a typed letter to the Chief Justice of a particular court and to the other judges, accompanying judges of the court, can be written, which can as simply say that to the Chief Justice of, let's say, Delhi High Court and the accompanying sitting judges, and you can write your grievances. You can write dear sir, or the dear madam, respected sir, respected madam. You can write the subject of a public interest litigation, and then you can lay out the facts for which you are coming to the court, and then towards the end you can have a small prayer. So that can be as simple a format as possible for a public interest litigation. The other method of agitating courts is obviously through writ petitions, which are treated also as public interest litigation, for which whatever writ you want to agitate before the court, be it habeas corpus, be it mandamus, be it quo warranto, be it certiorari, there are all those writs. Accordingly, you can research the case laws which are already available in the public domain. You can, if you have subscription to one of the legal websites like Manupatra or SCC or other websites, you can log in, do some good research, and accordingly make a petition. In that petition, you have to have the body of fact narrating in chronology one, the list of dates and the events which has given rise to this public interest litigation. Thereafter, you have to narrate the story in the most logical and clear and a cogent manner to the court, why you're coming to the court. Then you have to have raise the pertinent questions of law, which according to you, a court must adhere and listen in order to entertain a public interest litigation. And the end part of any work of pleading is the prayer that you are seeking from the court, or the relief that you are seeking from the court. Now, let me give you an example of this WhatsApp thing, which happened in February, where the news was that WhatsApp is going to breach into your privacy and has this mechanism which is coming out, by which the privacy functions are going to get distorted. And I think few public interest litigations were lodged in Delhi High Court. Few of them were dismissed, where the court pointedly asked the petitioner that what is the locus, why are you coming to us? You have not even done proper research. What is your point? And how can you say that WhatsApp is going to breach the privacy, and that is why it is going to be violative of either the fundamental rights or any other rights which are enshrined and given to you under the Constitution of India. So some of the petition did not have an answer to this. Subsequently, I think a group of lawyers formulated a very good petition. They made a very good case before the Delhi High Court and said, look, these are the particular grounds that we want to agitate before this honorable court. And that is why we think that particular act which WhatsApp as a company is thinking of getting into public domain and into the domain of its users who are using WhatsApp on a daily basis will be violative of their privacy, will be violative of the freedom that the internet gives them, will be violative of other things which have been enshrined under the Information Technology Act. So they pleaded the court that please look into it. And I think the court, the matter is still sub judice. The court was hearing those matters. Now, off late, I think since March, when the lockdown has happened, multiple courts across the country, including the Delhi High Court and the Supreme Court of India, have taken cognizance of various public interest litigations, either suo motu or in petitions which have been forwarded by public spirited citizens. An unfortunate incident that I read in the newspaper also of a public interest litigation was of a case which was agitated by a practicing lawyer regarding his brother to be receiving a hospital bed in one of the hospitals in Delhi. And every day he was requesting the government to provide a bed, but the court had to tell him with utmost sincerity and difficulty is that, look, we cannot give lawyers special treatment as a class when especially people of the country are dying left, right, and center, and we have to help people equally. But before the case could come to a conclusion, this lawyer told the court that please do not carry on the matter forward. My brother has died. So things are very tough. All I would say is whenever you plan to put a public interest litigation in the court, and especially in these times when we are struggling with Corona, when the judiciary is struggling from Corona, when we are hearing unfortunate news of judges passing away because of COVID, or court staff or judges succumbing to COVID and are suffering and are COVID positive, including some of the famous judges of the country today, please bear in mind that you do not put a public interest litigation just for the sake of it. Please do not be a part of a publicity interest litigation, which has time and again been dismissed by our courts with sometimes very, very high cost. In fact, I'll tell you, Madhur, I think just 2, 3 days ago, I was reading, was it Bar in the Bench or Live Law, that one of the law student had filed a public interest litigation, uh, and I'm not recalling the subject of the PL, but it was dismissed. I think it's 5,000 or 10,000 rupees cost, with a very, very frivolous subject. I'm just completely, the subject has, I'm not recalling it right now, but you can find it on Bar and Bench and Live Law. And a cost was imposed on this young law student that please don't bring frivolous petitions to the court and waste the valuable time of court. So to all the audience, I will say, before you start drafting any petition, please do your research very well. As I said, there are multiple subscription available. Even I think there is Indian Kanun, which is free of cost, where you can look for judgments if there are financial constraints at your end. The other way to do a good research, because whenever you file a PIL, you have to make one of the government a party. It can be central government, or it can be state government, or it can be a municipal body. It can be any government department. It can be a police department if it's a matter of police atrocity, etc. So please do your research beforehand. If you think you have time at hand, and if you can do that research, let's say in a given span of time, I would also suggest please use the Right to Information Act to your advantage. Many a times it is seen that when you file RTI application, normally within 30 days you get an answer if your questions are pertinent. And if you have a RTI, question and answer series with you, and sometimes let's say the RTI may not give you all the answers, then at least provides you a locus to formulate a PIL and tell the court, look, I went to this department, I filed a right to RTI application, but no proper answer was given to me. People are suffering. Now you can request the court to take a cognizance. If there is utmost urgency, like we are facing today in the time of corona, of oxygen cylinders, of hospitals coming to court and filing public interest litigation saying, look, we are running out of oxygen, please provide us immediate help. Those petitions have been heard late night by different courts in the country, telling the government, please provide oxygen tankers to go without checking, without barricading across the borders of the country. So those petitions have also been heard, and those are super urgent matters which have been taken as public interest litigation. Otherwise, in which valuable time would have been wasted. To keep it very brief, please do your research properly. We have all the research modules. We have all the research engines available to us. Be very, very thorough with your research. Please do not go to the court thinking that just because you will file a PL, you will become famous. That should not be your initiative. Your motive should be very clear. It should be for public good. It should be for helping the people of this country. It should be for helping people who really need help, and not just because let's say you think that because let's say Netflix has launched a series, or let's say there was a series, Z5 launching Radhe, and you don't like, let's say, Radhe movie, and you think it's a flop in your mind. You go to the court and file a public interest litigation that the OTT streaming of Radhe will stop. The court will be angry at you. The court will say you are wasting my time. It is not a matter of public interest. It's a matter of publicity interest. A movie had to be made. A movie was launched. It doesn't affect the society. A person is free to watch a movie, and a person is free not to watch a movie. So it's not a matter of public interest. But yes, where I think a trailer of a particular movie or any other movie may suggest that there are scenes which will affect the youth of this country, or which are too sexually explicit, where perhaps some sort of embargo may be placed. Maybe then you can go to the court with proper research and making other like the Cable Television Act you must read, then the Press Trust of Council of India, the other rules and regulations of IT Act, OTT platform regulations which have now come by the Ministry of Information Technology and Broadcasting. Read those things before you jump to the court. Just don't go there because your sentiments are hurt, or emotionally you feel that I have to do something. So never be in a hurry to go to court. I think the idea always is think as a lawyer, and I'm saying especially to law students, you are the future of this profession. Tomorrow you are going to be practicing lawyers, so do a very robust research, have a chronology, have your annexures ready to be filed along with your PIL. There may be case laws, there may be RT applications, there may be the answers to RT applications, there may be research that you may have done from international law journals or national legal journals, or maybe any good and reliable news report that you may have found either online or in international media. But you have to doubly verify it before taking it to the court. Now, just because, and please do not rely on WhatsApp information, or this WhatsApp university, as we popularly call it, because let's say you find something in WhatsApp, and without doing, enough cross-checking or double-checking of a particular source, you go to a court in a PL and you say, I read this on WhatsApp. The court is going to dismiss your petition and file a heavy cost on you. So, my dear friends, please do not do that. As somebody who practices in court regularly, and I currently am also representing the union government in Delhi High Court, and I am a part of these writ petitions, and sometimes these petitions which are also public interest, which come my way, and I have to advise clients, I have to advise the government, how to go about it. And in the same vein, I must tell you that if your research is improper, if your knowledge of constitution is not up to the mark, please brush it up. Read. We have enough research. We have enough judgments. As I said, even if you read MC Mehta's judgment, there are hundreds of them. You will get a sneak peek into what the court thinks in matters of public interest litigation. If you think there is illegal mining going around in your area, please do a research. Please read Mines and Minerals Act. Please read Supreme Court judgments on mines and minerals and how it impacts the environment. If you think it's a matter of bounded labor or domestic violence happening in your vicinity, please read the Domestic Violence Act. Please read other things. So I always say, go to the first principles, and first principles are your statutes, which are framed by the parliament or the state government. Please read them from top to bottom. Look at the pertinent sections. Look if they are getting violated. Look if there is a violation of law. And then, as I said, the body will be first the narration of facts, and before that, the list of dates and events. Then, in a chronological manner, what do you think has gone wrong in a particular matter? And then formulate questions of law. And after you have formulated questions of law, put your prayer and the relief that you're seeking. It's as simple as that. It's not rocket science, but yes, don't make it complicated for you. Do not make it a rocket science for you by complicating the matter and by not doing this bit of hard work which is required from your end as a petitioner in person, or as a petitioner who may be engaging a lawyer to put a public interest litigation to court. With this, Madhur, I think I must pause my speech here. And if there are any questions, from your guest, I'm more than happy to answer them.
So there is a question based on what you said that recent news that some student has faced a 5,000 or 10,000 of penalty. Like previously, we have heard that such type of penalty has been imposed, even like 50,000 or 1 lakhs of penalty. I once read. I think in last year. What are the key points that a student, like a law student, while filing a PIL, should keep into the mind that he should not at least end in that side where he is facing a lot of penalties in monetary terms?
See, to face penalty, the first thing is, have you done enough research to go to the court? Has the court already looked into a matter like this? Even if you can't find something on Manupatra or SPC, you have this. Today we have the judicial data grid where the whole information from the courts across the country is given on one website. You can individually go to the court website where you want to file your PIL and look at the cause list of a court. Try to research within the court website whether a similar case is pending or not. Try contacting your seniors or lawyer friends to ask them whether a similar case is pending or not. Because the first principle, which is taught to any of us when we enter law school, is ignorantio legis non excusat, meaning ignorance of law is no excuse. And especially as a law student, when you're going to a court and wasting the time of the court in a frivolous PL, you are going to get slapped with a very heavy cost.
Surely, sir. So there is a question coming from Mr. Om Gupta that what should be the ideal format and where I can find that?
So it's something like you're asking me how to find the right bride for the marriage, or the right groom for a marriage. There is no ideal or right format. These are all available on Google. As I said, even a simple letter to the Chief Justice of a particular court or to the Chief Justice of India, if you're planning to go to the Supreme Court, will suffice. I'll give you an example. A few years ago, in Amity Law School, which is affiliated to IP University, some of my interns, their batchmate had committed suicide. This young boy, and one of his friends, was so disturbed by this incident that he just wrote a letter, I think a 5-6 page letter to the CJI, to the Chief Justice of India in Supreme Court. And the matter was treated as a public interest litigation, and union and the Delhi government and Indraprastha University and Amity Law School and other institutions were also made a party to this public interest litigation, because a young man had died, and the allegation was, it's not a simple matter of suicide. He was driven to commit suicide, and I think subsequently then the matter, I think, was also transferred to the Delhi High Court by the Supreme Court. So again, as I said, there is no ideal format. But yes, please have your facts very clear. And if you still want to look for ideal format, I would say contact a lawyer who drafts writ petitions, or who has a good knowledge of court, how the filing is done, how the listing is done. Lawyers are the right people to guide you at the end of the day to how to go about the court, and also how to argue a matter and put a point across. You as a layperson may think what I'm doing is right, and perhaps you may write one letter to the chief and it may become public interest litigation. But please understand this, that if the court may ask you to argue, and if you're not in a position to argue, then your public interest litigation will fall flat in one or two hearings. So you have either to have a proper lawyer on your side, or you yourself should do a proper research for filing a public interest litigation.
That was great, sir. Thank you. So the next question is coming from Kushal Bhattacharya. This question is quite away from drafting part. The question is quite different. It's can we say that PIL is related to utilitarian theory of Bentham in a way?
Sir, nothing is utilitarian. I mean, look, it's too far-fetched a question. PIL is just
Yes.
a mechanism to remedy, the maladies in the society, if I may say so. And if you think there is something wrong, please bring it to the notice of the court. But before you bring it to the notice of the court, go to the, for example, if I see too many potholes in the road in my society, or in my vicinity, or in my neighborhood where I'm living, and if I, despite repeated complaints to a municipality, or let's say municipality of Delhi, or municipality of Noida, or Ghaziabad, or Faridabad, wherever you may live, they do not, take cognizance of a matter, then obviously you have to file a public interest litigation saying that, look, accidents are happening. People in two-wheelers, four-wheelers are dying because of this, or getting injured because there are repeated potholes. There is a improper drainage system. Please bring them to task. So court has to do something about it, right? So again, a utilitarian theory or not, you have to be public spirited in your approach.
Great. So this was a great answer indeed. So we are getting quite more questions. I'll take 30 seconds. So the next question is what we should keep in mind while mentioning the issue of law in the PIL drafts.
Sir, the issue is simple. One, know the story. The story that you're going to tell the court has to be a believable story. If that is something which is affecting the society, the cause, you just cannot go to the court saying my fan is not working, my AC is not working. There is electricity cut in my society. Then go and complain to the society people or to the electricity department. That cannot be a court's domain to entertain. But let's say if there is a widespread electricity theft happening in a society which is not being remedied by the agency or by the government department, then write a complaint to them. If no action is taken, then go to the court. So you have to think the cause that you have to bring to the court for the larger inter-society. You just cannot say my Wi-Fi is not working. And if the Wi-Fi is not working, you have to complain to the Wi-Fi body. The court is not going to come to rectify your Wi-Fi. So you have to be very, very clear in your head about the agendas. Are the agendas related to you or your convenience sitting at home? Or is the agenda something which is, for example, oxygen cylinder is a real agenda where the society is suffering,
Yes,
hospitals
sir.
are suffering. So that is the agenda which has to be brought to the notice of the court. And courts have themselves now taken so much cognizance, knowing that people's life are at stake. So for example, if you see people by and large flouting and not wearing masks, that is the agenda that you must bring to the notice of the court. If you see that the police in the while at the barricading are themselves not wearing the mask, that is something you must bring to the notice of the court. But please realize, do not burden the courts unnecessarily. There are certain things which you can handle at your level, at the administrative level, and there are things which are of utmost importance, which should be brought to the court. For example, when the Vishaka guidelines were laid down in 1996, when there was no guidelines for sexual harassment at office or workplace in the country, then back in 96, 97, the Supreme Court had laid down Vishaka guidelines, and the POSH Act only came into being in 2012 or 13. You know, so imagine so many years ago somebody thought of these guidelines to be agitated. It was in public good. And similarly, when bonded labor, child labor issues were cropped up, again we had public interest litigation. When we think of mining, when we think of forest fires in Uttarakhand, even I think the Nainital High Court has taken cognizance of forest fires. How come forest wildfires, are so rapidly increasing and damaging the ecosystem. So all those things have to be brought. Just because, let's say there is a fire in your dustbin in the house, that does not become an issue of public interest litigation. A forest fire becomes a matter of public interest litigation. So this is something that you have to bear in mind. A larger public goal, a larger public interest has to be the crux and the fulcrum of a PIL.
Yes, sir. So basically, the crux is that public at large should be a concern rather than public in person, in private.
Absolutely.
Great, sir. There is another question. This is more sort of inquisitive, at an inquisitive side. By your permission, I will ask if there is any PIL pending in the court, can the police take any action against the authority who filed the PIL?
See, depends. If it's a PIL where police has made a party, then we'll have to think about it. You'll also have to see whether any interim orders have been passed by the court, or whether a stay has been given. So that's too hypothetical a question. You will have to see the actual proceedings of a court in a in a particular PIL, or in a matter which is of public interest litigation, whether any interim orders are passed or not. For example, I'll tell you, when I was representing state of Rajasthan in Supreme Court, from 14 to 19, there was a public interest litigation I was a part of, which was about shelter homes in different states, and how shelter homes should provide warm blankets and a roof to stay for the people, especially during the winter months. And almost every state in the country was made a party in this public interest litigation, from J&K to Kerala to state of Gujarat. All the states and union government was a party, and everybody had to give the report, to the court, what as a state they have done. So for example, as I said, every PIL is of a different flavor. The nature of the PIL differs from context to context. So you'll have to see how the proceedings are panning out in the court, and whether what are the interim orders, if there are any interim orders which are passed by a particular court in a PIL proceeding.
Great, sir. So the next question is, you can choose to skip this question because, to be honest, it's kind of a comment, direct comment. I'll be putting the question directly. It is, I live near Ganga Basin where a lot of mining takes place. Workers do mining for survival. Various PILs have been filed by local lawyers, but money clears the way. What more concrete steps can be done?
So if you have filed multiple PILs, my question to you is, one, are all those PILs pending, or have they been dismissed? If they are pending, what is the outcome of those PILs? Whether they have been decided or not, whether any judgment has been passed on them or not. Judgment has been
Exactly.
passed on them, then have you appealed it to Supreme Court? Because I'm considering the PIL would be before the State High Court. So I think it's a factual scenario. You'll have to give me more details, and I don't think the webinar is the right platform, because there is a confidentiality attached to the
Exactly.
proceedings which you're talking about. So you can always reach out to me on LinkedIn on a direct message, and tell me about those things, and my office can get in touch with you.
Exactly, sir. Well said, sir. The next question is, is there any certain difference between a writ petition and PIL?
So yes, writ petition is categorically defined under Article 32-226, and PIL, as I said, is more of a judicial activism, the concept which has now been, as a matter of custom and repeated judgments by the Supreme Court, has been laid down in our Indian jurisprudence, which becomes by default a part of writ jurisdiction, because in writ you are by default directing a government or a state body under the writ power, which is inherent in the constitution, by both the courts, to direct them to do a particular act which a state or a central government is failing to do.
All right, sir. So it was a really great session till now. If anyone has any question remaining, we still have 10 minutes. You can put it up. The question is, what is for the process if there is misuse of PIL? I think sir has already answered it, that if court won't feel that, if court will feel that it is the time of court is being taken unnecessarily, then a fine can be imposed. I think, sir, this is sufficient answer for this.
Sorry.
The question was, what is the further process if there is misuse of PIL?
If there is dismissal of PIL.
Misuse of PIL.
Sorry, I can't hear the word. Misuse of PIL.
Yes, sir.
Obviously, it will be dismissed with cost.
Yes.
And there is no upper limit to cost. It can be 5,000, 5 lakh, depending on the judges and the court's mood. I think you'll be the outcome will be meted out to the petitioner who is doing a publicity interest litigation or a politically interest litigation.
Sir, a complex question according to me is coming, that is every matter of public interest can be a matter of public interest litigation?
Say again, if a matter public.
Every matter of public interest can be a matter of public interest litigation or not.
See, it can be, but again, the steps that you have taken prior to coming to a court, what is your goodwill? You'll have to prove your case, before a court. If there is an alternate remedy available, and you don't have to go to court on every PIL. For example, if a FIR can be lodged for a criminal matter, you don't have to go to a court to agitate, a PIL on a criminal side. For example, if there is a domestic violence act, you cannot go to the court that your mother-in-law is troubling you. That is not public interest litigation. So a public interest matter has to be taken very seriously, where a large fraction of the society is affected by a particular, act or omission of a state agency.
So another question is, if private universities violates UGC guidelines, can a PIL be filed against them?
You can first see, what are the guidelines they are, flouting. Because if UGC is flouting, you can take it. Or you can write a letter to the UGC and say these are the guidelines being flouted. There are mechanisms in law. If not, you can, there are different things that, different legal formats in which you can agitate your claim.
Definitely, sir. I don't think there are more questions from the students. If still there is any question, you can put up in next couple of minutes. Either we'll proceed towards end of this session. So it was really a very fruitful session. I think all the doubts of the students is quite clear in the last whatever you said in last 40-50 minutes, and it was really really a blessing to hear you throughout.
Thank you so much for having me, and I wish you all the best. And please keep safe, stay home, and take good care of yourselves.
Thank you, sir. I would also like to inform all the students that we are also organizing a PIL drafting competition. In case you want to participate in that, stay connected with us and we'll share a link for the same. Thank you for being here, sir. Thank you. I would once again announce with the students that we are organizing a PIL drafting competition, that is a national level competition with internship opportunity and in chambers of Ms. Himanshali Gautam, and also you will get a publication opportunity in blog in case you want to take part in that PIL drafting competition. And whatever you have learned in this particular session, you can utilize this learning by taking part in that PIL drafting competition. You can connect with us, and we'll definitely be sharing a link for registration of the competition in the WhatsApp group from which you have joined this webinar. I would extend my warm thanks and a thanks from the behalf of Lexpeeps family for joining us in this session. Thank you, everyone.